Heather Nicole Johnson for the movement, Christel Smith.
And Anika for Samuel Smith.
Prior to going on the record, the court asked about any preliminary matters that needed to be taken up, and Attorney Nika, I believe you had the floor.
Yes, the pleadings cite the marital settlement agreement, which is not a portion of, which has been quoted as what's been violated. And the marital settlement agreement is not incorporated into the judgment that has been registered as the foreign judgment in this court. So therefore, it's a motion on no judgment, in our opinion. There are no instructions for determining if there's a valid cause, the date and time of reimbursement, method of reimbursement. None of that is in the order. In addition, according to 157.002A2, which you mentioned before in Slavin, it has to state the manner of the respondent's non-compliance. This is a motion for enforcement of payment of extracurricular activity fees and for unreimbursed medical expenses. And there is nothing in the pleadings that state, it just says the date and amount due. It doesn't state any identifying information about what is due and what it's for. So therefore, we have no way to prepare for violations. My client doesn't have clear notice on what $111 on March 30th is for, or to either defend the lawsuit or to be able to even comply with their request. So we're asking for a dismissal, or, and then the other argument we have is for clarification, because the order itself is ambiguous. It's ambiguous when it's reasonably susceptible to more than one meaning, obviously. They don't define what an extracurricular activity is. Is this a school-sponsored event? Is this dance classes that anybody can sign the kid up for? Is this agreed to or not agreed to? And also the specific order, which is not cited here, but just for the court's reference, it states, father and mother will discuss major issues and make these decisions together. And it specifically talks about elective surgery, education, general health and safety issues. And then later on it says, mother has tie-breaking authority, which basically gives her the exclusive right.
Hold on, counsel, where are you reading from?
This is page 3 of the judgment of absolute divorce.
Okay.
I'm sorry, it's page 3 of the parenting plan agreement, which is an attachment to the absolute divorce.
All right, hold on one second. Okay, the judgment of absolute divorce that I see is just 2 pages long.
That's true. Then there's a parenting plan agreement, which is attached and incorporated into the judgment.
I'm not seeing that with the exhibit. Counsel, the exhibits that you sent only has those 2 pages.
So there is an incorporation. I'm trying to open mine as well, Your Honor. Give me 1 second.
The original filing has the registered judgment.
Yeah, and that's the motion for enforcement.
No, the original filing in this case.
Oh, okay.
Is the registration of the foreign judgment, which doesn't include the marital settlement agreement. The judgment is just based on that agreement, like an MSA.
What is the date that you're looking at on that?
This is from
the registration of the foreign judgment.
Oh, it's from 2023. I don't know it's the original filing in this case.
All right, I think I found it. Okay, page 3. I have it.
At the parenting plan, page 3, it says it's under GA, decision-making, major decisions. So it's not clear who gets to make these decisions. And then we're trying to enforce payments for elective surgeries, elective therapy, and several elective options as well. We think, we can't tell from what these charges are from the pleadings, but we think they're elective, and we don't know who gets to make those decisions. So if not dismissed, it at least just needs to be clarified rather than an enforcement proceeding.
Thank you, counsel. Response?
Yes, Your Honor. Well, for starters, with respect to what is clarified or on its face on the motion, if we go to page 2 and page 3, the actual language from, and I will concede that these orders, since they're from another state, are quite different than what we're used to seeing. But the language that is used in the order is all that the party had to work with. So that is included, and it specifies exactly what Mr. Smith's obligation was, under which particular order and document that under which it was rendered for him to comply with that obligation. It specifies what was health insurance, even in beginning on page 3, section 8. It states that this list going through, or for these particular violations, are all for the extracurricular activities. The next set of violations, all of these are for healthcare expenses. And then so it's broken up into 2 sections. So it's very clear on its face and gives sufficient notice to the respondent as to the purpose that for each one of these expenses that my client submitted to him, as she was obligated to do if she wanted to be reimbursed. Also, with respect to the manner in which he failed to make the payment, specifically the controlling order under which we are seeking the contempt finding, there is no specified manner by which he was supposed to do any of that. So we can't create one just for the sake of the motion. Further, I am in agreement. A clarification by this court would be fantastic, because it would clarify from, I guess you could say, from a Texas litigation standpoint, the way we do things here, what this order needs to look like. But all in all, that does not change the fact that he failed to comply. So we do ask the court to proceed on hearing these particular alleged violations by Mrs. Smith of these expenses that she has not been reimbursed for by Mr. Smith. And also, if the court does find any language that needs to be clarified, we are totally in favor of that, Your Honor. And also, I believe there was an issue, Your Honor, with respect to the Maryland order here from Prince George's County, that particular judgment and settlement agreement do appear in the minutes of the court. It has been filed with the clerks of the court.
I'm looking at the marital settlement agreement. Is this the one that is 13 pages long?
Yes, Your Honor.
So that was incorporated into the absolute judgment?
Yes, Your Honor.
I didn't see it. I read the absolute judgment. I did not see it incorporated in there, and we did not, when we registered the foreign judgment, did not include it. So therefore, it's not a Texas order because it hasn't been part of the registered foreign judgment. And that's the part that says reimburse wife within 15 days of receipt. The actual absolute judgment doesn't have any of that language.
So whoever drafted the order in Maryland just didn't bring the language over, right?
That's what it sounds like.
Yeah, okay. The court can clarify an order and without making substantive changes. So the manner, like the 15-day, because you all have to be able to, he has to be on notice. He has to be able to follow it. So the court can clarify some things. Now, some things I can't do because it'll make a substantive change to the underlying order. So let me just make sure I'm clear. The issues are the failure to reimburse, extracurricular activities, and health insurance reimbursement.
Yes, Your Honor.
Okay. And counsel, what you're saying is that your client is not on notice.
Right. We don't know what any of these charges are for. I mean, what extracurricular activity was $1,500? I mean, I don't, and is that something that needs to be agreed to, extracurricular activities, if they're that much money?
You're saying the total?
Correct.
Okay.
See it on page 3 of the motion, March 5th, 2024. There's a bunch of charges adding up to about, I don't know, $1,600, $1,700. I mean, but it's not identified in this pleading as to what that was for, so we don't even know if it's a legitimate.
Well, Your Honor, by virtue of the evidence and my client's testimony, we can demonstrate what these expenses are for. She provided or submitted receipts to him at the time for the expenses, which clarified what they were for.
We don't have any of the receipts and they're not exhibits, so I don't know how that's gonna be shown.
Your client just gonna testify to what she paid, because I don't have any exhibits with the receipts.
She can testify as to what she paid, Your Honor, as well as what what the reason for those expenses.
Okay,
Yes.
so the court is going to deny the request to dismiss the case. The court, if after hearing testimony, the court decides that a clarification will be done, I will tell you all how we're going to clarify it. But I do need to hear testimony from the both of them to be able to make that decision. So we're going to proceed with the hearing. You all have 15 minutes aside. Are there any other preliminary matters that the court needs to take up? Okay.
Not at this time.
Okay. All right. At this time, is anyone asking to invoke the rule?
No.
Okay. Counsel, you, attorney, because both of you are counsels, Attorney Johnson, you may call your first witness.
Honor, I would like to call Samuel Maxwell Smith.
All right. Sir, if you just come sit in this seat here and make sure the microphone is pulled as close to your mouth as possible.
Thank you. May I bring on?
What's on it?
You could take a blank one, but
Yes, a blank one, yes.
Right.
Okay. Right? Counsel, you may proceed.
15 minutes.
Yes.
Mr. Smith, can you state your name for the court?
Samuel Maxwell Smith.
And you were a party in Maryland divorce case in 2020, correct?
Yes.
Just make sure you speak directly into the microphone. There you go.
Yes, Your Honor.
And that judgment from that case, it was a judgment of absolute divorce, included a marital settlement agreement, right?
Yes.
And you signed that agreement voluntarily, correct?
Yes.
You understood that it required you to reimburse my client within 15 days of receiving receipts, correct?
Yes.
And you
this
were,
point, we would like to object, and we were asking for another motion to dismiss. In this case, this is obviously a quasi criminal proceeding. I'm assuming they're going forward on the petitioner's second amended motion for enforcement of child support order. We were served with an order to appear that said, that is ordered to appear for a motion for enforcement of the child support order, not a second amended motion for a child support order. So we're asking that this case be dismissed for not enough notice and for my client's due process rights. The order must state with clarity, specifically and unambiguously, and we were not properly noticed of the hearing on the order to appear. We're asking that double jeopardy attached.
Okay, response.
Honor, he has already taken the stand. He has already begun answering questions. And the court gave us an opportunity to put on or to present any defenses before this hearing begun, and counsel did not subscribe. Now, with respect to double jeopardy attaching, there was never any service on Mr. Smith until the time between the last time we were here and today. That is the only reason we've been able to go forward. It's not as though he's been sworn in to reappear. So the proceedings did not actually begin until today.
I remember he wasn't here the last time.
No, he was not. He had not been served.
We had agreed to reset it because he couldn't get here because he flew in from Maryland for the hearing and he couldn't get to the last one. So we agreed to a reset. They filed and served him with another order to appear and the second amended motion for enforcement. The order to appear states where to appear for a motion for enforcement. They served us with a second amended motion for enforcement. So I don't know which one we're here for today.
Well, Your Honor, even if we're on the original, it doesn't change my line of questioning.
So the second amended motion was filed on March 11, 2025. Correct?
That sounds about right, Your Honor. Yes.
All right, and then we had a contempt hearing in May. Let me just go back through my notes. All right, so there was a contempt hearing that was set in May, and then we had it reset. Okay, those are petitions to modify. So specifically on the enforcement, we agreed to a reset date, which is today.
And then he was served again with an order to appear in the second amended motion. The order to appear does not notify him that it's on the second amended motion. It notifies him of a motion for enforcement. They've started the case on the second amended motion for enforcement. We're asking that it be dismissed for not proper notice.
Okay, so after we agreed to reset, you all amended the motion?
They served him with another order to appear for today's hearing.
I guess where the disconnect is, he was served to be here. We agreed to reset it today on the second motion for enforcement.
We set the hearing, which was notice for motion for enforcement the first time.
Okay, so not the second motion.
So then, after we reset it, they filed another order to appear and served him with that order to appear, which also said motion for enforcement. None of the order to appears have ever said second amended motion for enforcement, even though it's been on file.
Right, I get that. However, we reset it on the second amended motion.
I don't know what we were saying. We were here for the motion for enforcement for that hearing.
No, it's clear. We reset it for the second amended motion to appear.
But what I'm saying is the order to appear doesn't say it's for the second amended motion. And for a quasi-criminal case, it has to be a very clear notice of what case we're here on and whether it's the second amended or on either it's the motion for enforcement. They've already started on the second amended, so we're asking that it be dismissed because he didn't have proper notice that it was the second amended and not the motion for enforcement, which is what the order to appear says.
Well, I can't put him in jail anyway. This is for extracurriculars and health insurance. This is not child support. So, I mean, are you all removing the contempt? Because you can do, I mean, it's disingenuous to show up today for a second amendment and say, hey, they did this order to appear subsequent of that when I reset it based on availability. I think that argument is very disingenuous because, and I'm not saying that mistakes don't happen and the order to appear didn't say whatever it needs to say, but I reset it. The court reset it, and I said it on good faith grounds that you all needed more time. So to come in here today and say, hey, we want to dismiss this case after we agreed to reset it today, I don't believe that's fair to either one of them.
Well, we just didn't have time to have reviewed it by that.
Yeah, counsel, no. I reset it. The court reset it. You all didn't reset it. I did. So how do I go back on something that I did in good faith based on what you all told me you needed?
We're saying that the second order to appear didn't identify what this hearing was for, so it was unclear, even if we reset it for the second amended motion, order to appear says regular motion for enforcement.
Well, even if, honestly, I don't know why an order to reappear was even sent. Maybe that's just habit.
I think
Based-
it's be out, Your Honor.
Or maybe, or it could have been. I don't necessarily know. All I know is that you all came in front of me. We went on the record and we reset it based on the second amended motion. I remember it vividly because I remember your client being upset that we had to reset it. I remember it vividly. That's the only reason why I reset it. And I made it clear that the next time that we came on the second amendment, amended motion, that we would proceed.
I don't recall it being clear on which motion we were gonna proceed on, but that, I could easily be wrong.
Yeah, it was the second amended motion because that was their second time coming to court. I remember it vividly because when they walked in, I said, oh, I remember the parties. And I remember resetting it on that day for the second amendment. Like I said, while the order to appear was filed, I'm not gonna hold that against any attorney because I know habit. But according to the court's docket, we are here for the second amended motion, and that's what was reset back in May.
And I understand that, all I'm saying, all I was pointing out was that, never mind.
Okay,
Just pointing that out because it wasn't clear to me.
okay. Well, I think the record is clear.
Okay.
And yeah, so I did say that he can't go to jail anyway. Like, sir, I can't legally put you in jail, okay, for failing to pay extracurricular activities. I'm not allowed to do that by statute, okay?
Yes, Your Honor.
Okay. All right, counsel, you may proceed.
Thank you, Your Honor. I believe where I left off. Oh, Mr. Smith, I was asking you whether or not you understood that the agreement required you to reimburse my client within 15 days of receiving receipts from her.
Your Honor, we object. The marital agreement that may or may not have any requirements is not part of the order of the court.
Sustain. Just so we're clear, the court is proceeding based on the foreign judgment that is registered, which is the
Yeah.
judgment of absolute divorce.
Thank you, Your Honor. Mr. Smith, prior to today, you haven't alleged that the order is unclear, correct?
I have, is there any way you can repeat that, please, or rephrase?
Means that this order is unclear, correct?
That is incorrect. The Maryland order was extremely ambiguous, which was one of the reasons I wanted to bring it here to Texas so that we could get some more clarity, because I felt like it was being used unilaterally.
So when did you file your motion or petition to have the order clarified?
I'm not certain exactly. Could you rephrase it so I could understand
When
a little bit?
did you file a petition asking this court to clarify the order or the judgment?
The clarification was just when we were in Maryland.
No, I just want to know, when did you file for a clarification in this court?
I don't have the date at the,
But your testimony is that you have filed for a clarification?
no, that's not what I was.
1 second. Sustain, rephrase.
Mr. Smith, my client sent you receipts for the kids' extracurricular expenses, correct?
There were some sent, yes.
And she also sent you some receipts for their medical expenses as well, correct?
There were some sent, yes.
And those receipts included like medical copays for the boys, right?
In some of them, I can remember, yes.
Okay. And some of the activities were for their extracurriculars outside of school, correct?
Correct.
And you didn't reimburse her within the 15 days, correct?
It calls for a legal it's restating an order that's not an order.
Well, we can't read from it. However, he did admit in the beginning, let me scroll back. Okay, course apologies, sustain.
Mr. Smith, you've had an opportunity to review the motion that we're here on today.
I have had an opportunity to look over the paperwork, yes.
Okay. You would agree that you didn't pay any of the amounts that are listed in that motion, in this motion, correct?
Any of the amounts for
The extracurricular activities.
extracurricular activities, not to my knowledge.
You didn't pay any of the amounts for the medical expenses either, correct?
Not to my knowledge.
And you didn't dispute those expenses when my client sent them to you, did you?
They are in heavy dispute.
How did you dispute them?
I have emails, I have text messages for a long time asking to clarify, because many of these extracurricular activities, I declined them at the beginning of the year.
And your all of the things you've done did you bring that with you today?
They've been sent to my attorney. I could produce them in a moment.
Okay, can you go ahead and get them for me?
Sure. Would you like?
Oh, they're in your phone? They're not actual documents that you brought with you to court today?
If I can produce them,
No, I'm asking, did you physically print them off and bring them with you to court?
they're not physically printed, no.
Fine. So prior to today, you didn't ask the court. We already explained this or discussed this, but I'll just ask you one more time. You didn't ask the court for clarification before the motion for enforcement was filed by my client, correct?
I'm not sure what that means. Clarification on,
You stated earlier that you did not believe that the order was clear and that you wanted it clarified in the Texas courts. Wasn't that your testimony moments ago?
what I was speaking to moments ago is that when we,
Hold on one second. Let me streamline this because I don't want either attorney to run out of time. You didn't answer her question. Her question was, she said you stated earlier that you did not believe the order was clear and that you wanted it clarified in the Texas courts. Wasn't that your testimony moments ago? It's a yes or no.
I do want it clarified. Did I share with the court?
No, yes or no. You wanted, she restated what you said. So she said you stated earlier that you did not believe that the order was clear and that you wanted it clarified in the Texas courts. Wasn't that your testimony moments ago?
I did want everything that was not clear in Maryland because they write very loosely. I wanted everything to be handled here.
Okay, so the answer to her question would be yes then.
Yes.
Okay.
Thank you. Sorry.
You're welcome, no problem.
Thank you, Your Honor. And so just so we're clear, your share of the expenses was to be 73.9%, right?
Your Honor, we have checked. The pleadings don't have that portion of the order quoted as part of the portion that was violated.
I'm looking on page 3, number 8.
Correct. So where she quotes the order that was violated is on page 2, number 6 and number 7, which doesn't include anything about the proportional share amount. Proportional share amount. About the what? Proportional share amount.
So when I'm you're talking about referencing the underlying order? I'm looking at it on page 2, number 7. It says on October 13, 2020, and cause number CAD 20-06064, styled Christel K. Smith, plaintiff v. Samuel M. Smith, defendant in the Circuit Court of Prince George's County, Maryland. The court signed a judgment of absolute divorce that appears in the minutes of the court and incorporates documents style marital settlement agreement and parenting plan agreement. The 255th Judicial District Court of Dallas County, Texas has adopted the judgment to be a Texas order, and the aforementioned parts state this.
Right, and what she says, where she quotes what it says, it does not include the amount of the proportional share. Which is,
I see 73%.
it's on number 8, but it's not quoted as part of the, I'm just saying it's effective, that's all.
Your Honor, it is included in paragraph 8 prior to the listing of the allegations. It states what we're alleging for the violating the orders described above.
Yeah, counsel, I see it. It is there.
I'm just saying it's not quoted as part of the order. It's mentioned later on that it should be this amount, but it's not quoted. That's all I'm saying.
Okay, overruled. Counsel, you may continue.
Thank you, Your Honor. So, Mr. Smith, according to the order that the orders that we're discussing, your share was 73.9%, correct?
May I speak to that briefly?
Okay.
Your Honor?
You cannot, hold on one second. You cannot. You have to answer the questions that are asked. Now, if your attorney needs you to clarify something, she will then ask you. Just do
Understood.
yes or no.
Yeah.
It was 73.9%, correct?
Yes.
And you understand ultimately that my client was covering your share and her share.
No.
As of today, you've paid nothing towards these amounts, correct?
Towards which amount? Since when?
Listed in the motion, you've not paid any of these amounts.
No.
Correct, thank you. And you're not saying that my client refused your reimbursement, correct?
No.
You're not saying that she failed to send you any receipts, correct?
I'm not certain if I got all the receipts.
But
I'm
you
not.
know that she did not. You're not here today alleging that she failed to send you any, correct?
Correct.
Okay. And prior to today, until today, you've never asked for clarification of these underlying orders, correct?
I am interested. Could you rephrase, please? Because
The question was prior to today and until today, you never asked for clarification of these underlying orders. Is that correct?
ask for clarification from the court or from directly to Ms. Smith, or where?
Let's go with both. Have you asked Ms. Smith to clarify the orders?
I asked Ms. Smith
Yes.
to
Just want to know yes or no.
the orders. That's
It's a yes or no, sir.
I asked Ms. Smith to clarify the 73%.
Okay, and when did you ask the court to clarify the orders?
The 73% was based on,
When did you ask the court to clarify the orders that we're here on today? When did you ask the Texas courts to do that?
the clarification meant transferring it here to Texas.
The question was when. So a date or a time.
Modification.
Okay, so according to what your attorney just said, do you understand the difference between a clarification and a modification?
Not completely.
Okay.
Your Honor.
Counsel, you can rephrase it, you can move on.
I'm gonna move on, Your Honor. So Mr. Smith, the only reason that you didn't pay these obligations is because you chose not to, correct?
That is incorrect.
So you didn't seek clarification prior to today, correct? You just testified to that. You testified that you did in fact receive my client's
It's
receipt.
incorrect. I tried to get clarification.
Be allowed to finish my question?
Go ahead.
You testified moments ago that you did in fact receive the receipts from my client
Objection, that's a mistake.
and,
Sustain, rephrase.
okay. Are you here today alleging that my client failed to give you any receipts notifying you of these obligations?
I'm not sure if all the receipts were sent, but whatever she sent was sent. So how do I?
today that any of the dollar amounts listed in the motion, that she did not send you receipts for any of these these expenses listed in this motion?
I'm not saying that.
Okay,
No.
so you're not saying that. You're not saying that you didn't understand that you were to pay 73.9%, correct?
Correct.
Okay. So
I-
then the only option that would leave us with is that you didn't pay because you chose not to.
Is
Is
incorrect.
that true, Mr. Smith?
That there are other extenuating circumstances that I cannot.
Second, hold on 1 second. Wait for the next question. Go ahead.
Are you alleging financial hardship?
No, I'm not alleged. On whose behalf? Mine?
So if you are not alleging financial hardship, you received the receipts that you just confirmed you received from my client.
I apologize. What is financial hardship?
1 second. Hold on 1 second. Sustain. Next question.
Thank you. What is the reason that you did not comply with the court's orders?
Which orders? Are you referring to the 73%?
I'm referring to the orders that we're here on for today that were listed in this motion.
There were multiple reasons. May I list some?
I mean, she asked you, what were the reasons?
Yes, ma'am. Yes, Your Honor. Apologies. There are several reasons. The initial, this was part of our custody hearing, whereas the 73.9% was based on a number during the divorce in 2020 when Ms. Smith was a stay-at-home mom. She had shared that she had employment, and I asked, can we get it updated? So that the percentage would be accurate. Then I found out she was working for a Fortune 500 company. So the 73.9%
1 second.
was based, sorry.
I have to sustain it, but counsel, you asked him an open-ended question.
I have more.
I do
Hold on one
clarify that he's testifying beyond the scope of.
Okay, sustain to that. So anything prior to the order, you can't answer. You can't respond to that because it's not relevant to what happened after the order. So anything that happened prior to the order, any agreements that went into the finalization of the order is not relevant. So anything that's relevant is from the date that the order was entered, which I believe was 2020. That day to current. Does that make sense?
Help me just a little bit. Sorry, this is my education. So things that happened in 2024, would they matter? 2020, yeah, this is what.
After 2024.
Right.
So like you were mentioning about the, her being a stay-at-home mom and everything like that, those things wouldn't be relevant.
Understood. Thank you.
Okay, so, counsel, did you need him to continue with the reasons?
No, Your Honor, I don't.
Okay,
May I continue?
no. You have to wait on the next question.
Yes, Your Honor.
Just so we're clear, Mr. Smith, you've known at least since March 11, 2025, that these reimbursements were owed, correct?
Correct.
And even after.
Which ones? I'm sorry. Before I would like to read them again, but I would say yes.
Okay, let's go with yes. And even after being served, you still haven't paid them, right?
No, they were part of our custody hearing that got brought into this one.
Sustain.
Yeah.
Like I stated, sir, you're the client. Your attorney will clarify anything that you stated, and that's being asked, okay?
Yes, Your Honor.
Okay.
Mr. Smith, you understand that failure to comply with a court order is contempt, correct?
I'm learning how the system works. I don't know. Could you clarify some of that, please?
You do understand that when a person fails to comply with a court order, that is contempt.
In this case, I think it's ambiguous because,
Sustain.
okay,
You did not comply with the court order in this case, correct?
I'm not certain if I did or not.
Did you bring any evidence with you today to show that you did?
I have documents whenever my attorney gets to ask me. I don't know if it was submitted for today. We would have to.
Counsel, you have 2 minutes and 36 seconds.
That's the witness, Your Honor.
Okay.
Thank you.
Attorney Nika, you're welcome.
Mr. Smith, on January 23rd, 2024, did you receive a receipt for $142.58?
Yes,
What was that receipt for?
I'm not sure.
So are you saying you received receipts for all of these charges?
There were some receipts that were sent via the parenting app. We had started using. Was that the time we had started using the parenting app yet? I think we were given a parenting app. Either was that or a text message. I'm trying to recall.
Did the receipt say what the charges were for?
I'm not certain at this time. I don't have it in front of me.
Were any of the receipts for therapy?
Absolutely. More than half of what was sent was more than, let me be careful how I state it. A large portion of what was sent was for therapy.
Is this the you too?
Absolutely not. I do not think it was in good faith.
Objection. Non-responsive, number one.
Sustain.
And then number two, she's asking if it was medically necessary, but that has not, there's been no predicate to even get to medical necessity. They've not proffered any bills, any invoices.
Sustain.
So
We disagree.
Sustain.
Does your prior order specifically state that issues regarding elective surgery shall be made together?
Yes.
And did you agree to these charges? Did you agree to these treatments?
I'm sorry, which
GA, father and mother will discuss major issues regarding the children and make these decisions together. Major issues include, but are not limited to, elective surgery, education, general health, safety issues. Is that correct? And are some of these charges in your belief for elective surgeries or elective medical procedures?
some of them may be.
And did you agree to all of those?
I didn't agree to the surgery at all.
Extracurricular activities, do you know what any of these charges are for?
Some of them are for things that I did not consent to, and some of them maybe some of the kids stuff. Sammy J does track and field. There's basketball. Some of them may be in there, yes.
Dues for the extracurricular activity, or if they're for directly to the extracurricular activity fee?
Historically, a lot of things have been sent for shoes and things like that, and I.
leading.
Sustain, don't lead.
Okay.
So is it clear from this pleading what these are for?
Not all of them.
If you have a clarification of what these were for, would you be able to have the option, or not the option, but would you be able to determine if you can make those payments?
Objection, Your Honor, as to relevance, because willful compliance is totally separate from whether or not you agree to, or have certain rights and duties as a parent.
Your Honor, he has to have notice in order to be able to comply or to be able to defend the suit. If we don't know what any of these for, how is he next to know what to pay?
Your Honor,
Hold on. Let me stop the time. Your client testified that he received some of these, okay?
Correct.
And
Correct.
he testified too that he knew what his role was. Now, to the extent, maybe not, but in essence, you can't have it both ways. It can't be he's on notice, but he's not on notice.
The problem is that he may have received a receipt for March 13th for 254, but not March 31st of 59. We don't know if he had these receipts, if there was a spreadsheet or anything that said what these were even for. Then he could say, oh yeah, it's clearly extracurricular, I'll pay it.
Yeah, but that's on him. He agreed that he received some. I can't, right, but that's not the court's obligation. That's his responsibility to show what he received.
It's the petitioner's responsibility to show what she's.
It's her responsibility to show what she sent, absolutely. But he's corroborated what she said. Maybe not all of it, but he's corroborated it. So for me to sit here and try to cherry pick which ones that he's on notice of, that's not my job as the court. She only has to prove one allegation.
But we can't assume that all of them are valid to do a final judgment because we don't know what they're.
well, Your Honor,
Hold on, we cannot. That's not my role. She only has to prove one allegation here. One. He admitted, your client admitted under oath that he received some of them, maybe not all of them. You haven't put on his case in chief to show anything that he's received. Well, counsel, he's your witness.
Do you have any idea what receipts that you received of these?
There were some receipts in the parenting app that I had a lot of questions about. It was,
Okay.
what are the dates?
January of 2024 to November of 2024. I'm sorry.
Well, you can skip January 23rd because he admitted to that one already.
Did you receive a receipt for $142.58?
On what date?
January 23rd, 2024.
I don't have it in.
No, we're not doing that.
Okay.
He admitted that
Then
he
there
did
was-
receive it. It's right here.
Okay, what was that one for? Do you recall?
I don't recall.
Okay. And was it for an extracurricular activity or health expense?
What does it say? I'm not certain. I don't have it in front of me at the time. I'm not saying it was a no. I'm just saying I don't have it in front of me.
Is it clear to you what activities, as far as, are you supposed to be paying? What constitutes an extracurricular activity?
I am unclear. Because I was under the impression that we would agree to some of these extracurricular activities, and we did not agree.
irrelevant.
I sent emails.
But do you understand what an extracurricular activity is?
Objection asked and answered.
Sustain.
Do you know if an extracurricular activity includes the cost of buying shoes at the department store?
I was told that I wouldn't be responsible for shoes and things like that. Ms. Smith sent me messages saying that no, we're not going to do that anymore.
Your understanding from the order that medical decisions would be made, elective medical decisions would be made together.
Correct.
And did you make any payments for medically necessary?
Objection again, Your Honor, as to this medically necessary characterization.
And have you ever been directed by anyone not to make payments?
Not to my knowledge.
And If it wasn't clear to you, is that why you filed a modification in this case?
I filed, if that's the reason, yes, there is a reason that,
Second, let me read the question. Overruled. You may ask the next question.
Why did you file a modification in this case?
I have not been clear completely on how this percentage remained all of this time with Ms. Smith making far more money than I do, and I have a 73.9%. This was based on an old order. This has been changed since then. However, I am still being held responsible for times that she did not provide any income statements. So the percentage should have been different.
Second, wait on the next question.
Are you asking us to clear order so that you know what these charges are for and which ones that you're required to pay?
I would like the courts to go back and figure out the accurate distribution based on how much we actually made,
Well,
so that I can be able to pay the proper percentage, because that's why I would, yes. Some of these charges are from prior to that involves this percentage that was incorrect.
Let me explain. I don't know if this has been explained to you. The order, as it was written at the time, you can still be held, you can still have violated, okay, at the time that it was in effect. Now, the 73% may not be what you're paying any longer, but while it was under the court order that you were ordered to pay that, you can still be held in, and you can, let me not say that word because that's not what I'm trying to say. You can still have been found to have violated it while it was still in effect. Does that make sense?
Yes, sure.
So anything regarding the 73.9%, if you did not comply at that time, that's the reason why that motion is here. Does that make sense?
Understood.
Okay.
I understand a little bit better now.
Okay.
Do you have any idea how much you would owe for extracurricular activities that are valid charges?
I don't know no.
The amount of medical reimbursements that are listed on here, do you know which ones you might be liable for under the order?
Some of them I understand since October 31st until now. I am willing to pay any of those outright. The ones prior, I did not know if we could get an accurate income distribution so that the percentage would be fair.
Okay, that's another thing. Thank you for saying that. That has nothing to do with today.
Okay.
Yeah, nothing to
Okay.
do. I'm only responsible for seeing which order was in place. Was it violated? That's it. Anything regarding income distribution, that's what you will do with my associate judge for the modification. Does that make sense?
Understood. It makes
They're
better
two
sense.
different hearings. I know it runs together, but they're two different hearings, okay?
Understood.
Okay.
Yes, Your Honor.
Isn't it true that some of these violations are from after the temporary order and were not under the prior order? So for example, there's a charge for November 6th, 2024. Isn't it true that the Texas temporary orders were in place at that time?
Can you say that again? Sorry, I didn't understand.
Did the Texas temporary October 31st of 2020?
Correct.
So violations for any dates outside of that were not contained under the prior order. They're under the new Texas order. Is that correct?
Yes.
Your Honor, I just want to object, just to straighten the record.
What's the
temporary order-
what's the legal
The
objection?
legal objection would be that there's a mischaracterization of the timeline that she's giving for that. The court's record will reflect that the orders were not entered until after a certain amount of days or weeks after that
So
hearing.
this what the court is gonna do. The court is gonna take judicial notice of all contents of the court's file.
Yeah, so there was a rendition given on that date. Yeah, the orders weren't signed until we had them drafted, but the rendition was given as of the date of October.
Okay, so the court took judicial notice. That takes care of that. You may ask your next question.
Okay. I am with the question right now.
Okay. Attorney Nika, you have 1 minute and 57 seconds left. Attorney Johnson, you have 2 minutes and 23 seconds left. May this witness be excused?
Yes, Your Honor.
Okay, sir, you may return to your seat with your attorney, and counsel, you may call your next witness. Attorney Johnson, you may.
Thank you, Your Honor.
You're welcome.
Oh, Your Honor, I would like to call myself.
Okay, go ahead.
Second, I'm looking for. One thing, Your Honor, before I get started. Okay. Okay, Your Honor, I'm ready to proceed.
Go ahead.
Thank you, Your Honor. My name is Heather Nicole Johnson, and I represent Ms. Christel Smith, the movement in this enforcement action. I'm requesting $7,500 in attorney's fees, which are both reasonable and necessary based on the time and labor required in reviewing the client's file in this case, drafting the proposed order for today and preparing for today's hearing. While an enforcement is common, Your Honor, this matter still involved quite a number of violations, tracking multi-date reimbursements and interpreting an out-of-state order that we later adopted in Texas. In terms of the skill required, the matter required a family law lawyer experienced with enforcement, contempt, and child support reimbursement. My flat rate is $7,500, consistent with attorney's fees the range for Dallas County for attorneys with similar experience and services. This is a flat fee agreement. The court's setting today on today's date required, preparation in terms of getting ready for this on Thursday when we were notified kind of last minute that we needed to pop on to get exhibits to the court. Also, in terms of what's required for me to demonstrate, I am an experienced Texas family law attorney with a reputation for being thorough, ethical, and effective. I have represented Ms. Smith since about April 28th, 2025 of this matter. And I believe that the $7,500 fee is proportionate to the results sought and the work performed. The similar awards of fees in this range for this type of action range anywhere from $5,000 to $10,000 and are commonly awarded in similar enforcement cases involving contempt. I'm just going through the Rasmussen, I can never say it, Rasmussen factors. Also, under those factors as well, this case is not what we would consider undesirable, but the complexity and the number of violations did make it more tedious.
Okay, counsel, you just ran out of time.
I'm sorry, Your Honor, but I'll pass
Thank you.
myself.
Thank you. Any questions?
Yes, did you bring an itemized bill with you today?
I did, it's in my bill.
And did you submit that as an exhibit with the associate judge?
I do not believe that I did with Judge Lee. I did not.
And how many hours?
Probably including the visits to the courthouse, I would say anywhere from 10 to 15, but let me make sure I have
How much do you bill per hour?
this was not an hourly fee
How
case,
much do you generally bill per hour?
$350.
No further questions, Your Honor.
Okay. Counsel,
Yes, I'm getting the bill right here. Sorry.
and you rest?
Yes, Your Honor.
All right. Attorney Nika?
Yes, we call Christel Smith.
All right. Ms. Smith, you can have a seat. in the witness box, just make sure you pull the microphone close to your mouth.
Ms. Smith, on March 30th, 2024, you stated that you spent, is this $111 that you spent, or how much was spent?
So any price in there is the percentage that he's held to.
Okay, so this is not the full amount of what you paid.
No, I put together a spreadsheet and I put it where I had my percentage, he had his percentage, and the total amount that it's cost.
Okay, so March 30th of 2024, what was that amount for?
I'm not looking at my spreadsheet.
And did you provide that spreadsheet to me?
Yes, ma'am.
Would you be surprised to know that I've never received any spreadsheet with any descriptions of these things?
Objection relevance, Your Honor.
Overrule.
I sent it to Mr. Smith.
Would you be surprised to know that well, never mind. So on April 17th of 2024, you're saying he owes $84.32. What was that for?
If I'm able to look at the spreadsheet, I can tell you, because it's very detailed. It's a very detailed spreadsheet of what the item was, the amount.
Would you agree that this doesn't include any of that information?
So I didn't draft that up.
But would you agree that this doesn't include any of that
That's-
information?
You can answer that and that'll be your last question.
Repeat the question again, just to make sure.
I said, would you agree that this motion for enforcement doesn't include any of that information?
Any of what information?
Any of the information you're saying is detailed on a spreadsheet somewhere?
No, it's not. It does not have everything on it. No.
That's all. Your Honor.
Okay, thank you. Ma'am, you may return to your seat. I have a couple of questions. I'll start with you first, Ms. Smith. Each of the amounts due that you have listed on your motion, you said that that was what you sent to Mr. Smith?
Yes. Yes, ma'am.
Okay. How did you send notice to him?
I have an Excel spreadsheet and I also screenshot it since after the October 31st, I wasn't allowed to email him. I had to put everything in the parenting app. So there's multiple Excel printouts in the parenting app.
All right.
Very detailed, explaining the date, the time, what it was, if it was a medication, if it was a doctor's appointment. He has all of that.
Okay, thank you. Were you sending him the receipts in real time, or were you doing like a couple of days? How exactly were you sending him notice?
Real time, like, so if it happened within a matter of a day or two, maybe 3 days, he would have their actual receipt scanned, taken a picture and submitted in the parenting app prior to the temporary hearing. It was all in an email as an attachment. So
Okay.
it was the original, the attachment.
All right. And just for clarification, because I don't think either one of you said it, the therapy, was that therapy for the child?
Yes, ma'am.
Okay. All right. And Mr. Smith, you testified that the kids were in track and basketball?
Yes, Your Honor.
Okay, and you are aware that those are extracurricular activities, right?
Yes, Your Honor.
Okay. And you said that you did receive notice from Ms. Smith in the parenting app?
Yes, Your Honor.
If you,
For these charges, yes.
you have the list in front of you, right? The charges?
Yes, Your Honor.
Do you have you have the app on you?
I do have the app.
Okay, this is what we're going to do. We're going to take an intermission on this case because I need to catch these other 2 cases that are going on here. I want you all to pull those apps because, and this is so not typical, but I want to make sure that what you all, because your testimony kind of corroborates what she said. Now, you're saying you didn't receive all of them. In order for me to put on you an amount, I have to know for me what that amount is.
Okay.
And I believe your testimony that you did receive some of them, and I'm going with that. I just need to know which ones you received.
Yes, Your Honor. May I have one more question, please?
Yes.
One of the more than well, about half of what was sent is a counselor who is her church affiliate.
Okay, that has nothing to do with what I'm saying.
Okay.
A service was used for the benefit of your child, regardless, okay? So that's what we're going to do.
Yes, Your Honor.
Okay. So you all are on break. Miss Smith, Miss Smith. Did you all have an opportunity to speak? Okay, okay, let me move you all over. I was wondering why I couldn't see you.
Your Honor, when do you want us to come back?
Just check in whenever you're done.
Oh, just until they're,
Yeah,
okay.
The attorneys too. Yes.
Okay, can we leave our stuff or no?
Yeah, you can leave that there.
Okay.
You can leave your stuff there.
January.
Okay, do we need to go on the record yet, or did you all need to tell me something?
Well.
I had a feeling y'all had to tell me something.
Yeah, it looks like none of these charges, spreadsheets for none of these charges are in the app. It's just the new stuff.
Okay.
Since the prior temporary.
Okay, so. Okay. What about hold on, let me pull that motion back up. What about the healthcare expenses?
It's all in one spreadsheet. She puts healthcare and extracurricular all in one from what I could tell.
Okay, so the spreadsheet doesn't, just so I'm clear, the spreadsheet doesn't have any of these dates.
Correct. The ones on the app don't have any of those dates. She says she sent emails before, but on the app are none of these dates.
Yes.
Okay,
Have two separate timeframes, Your Honor. There is a period through October 29th, 2024, where the parties had not yet been ordered to enroll in an app. So my client was notifying him via email.
okay. Did y'all look at that?
Yes,
emails?
and I was gonna tell you, and so we have those emails, because she was smart, my client's really smart, but she numbered each time she sent it, 1, 2, 3, so we're all the way through 34 now.
And I don't have those emails.
So we have those, and then beginning November 14th, 2024, that's when the parties were enrolled on the app close. So that's why there should be subsequent dates, if any, in that app. For those.
Okay, so can y'all do that too with the emails?
Okay.
Yeah.
Yeah.
Because I know who lives out of town. You live out of town. Yeah, and I know you've been here a couple of times. So as much as I can kind of help mediate this, you know?
I mean, the only objection is that they didn't present the emails or any of that testimony or any of that evidence during the hearing.
But he admitted to receiving.
And that's my hang up, right? And that's really why I haven't went back on Zoom either, because he corroborated some of what she wrote here. So you all know this is not how a contempt hearing goes. You know this is not how a motion for enforcement hearing goes, but I'm trying to give grace because I don't want them to have to come back. And as much as we can get done today, that's what I would like to do. He admitted that she did send him notice of some. And I just want to know, were those these?
Yes. Well, how about this? If the court would like, I can go through them myself again, through the dates in the motion, as well as my client's emails, and then send that to.
No, we're going to do that today.
Well, no,
So,
I was
yeah.
gonna say I would do it today, but I'm saying like that way I can give her those, because I have to see it in writing. I can't.
No, I want y'all to do it right now.
Okay.
Just today. You all are already here. I don't want anybody to leave out of this courtroom not understanding what they're doing. Because we're also gonna clarify the order, because the
Okay.
order is real loose.
Right.
And both of you, for your sake in sending him notice and for your sake in receiving notice, because if not, y'all are gonna end right back, and your attorneys can tell you, you'll end right back up in here because your order does not specify how you're supposed to send notice and how he's supposed to respond after receiving notice.
You know, under some of these extracurricular activities, it's my understanding are for summer camps and those sorts of things. I mean, how do we account for that? Is that I mean, summer camp is, in my opinion, an extracurricular activity, but it's not clear.
So y'all have a modification pending, right?
Yeah,
You all are gonna discuss that in the modification.
that, it's not included in the temporary order.
Well, it may not be, but as you can see, it's an issue now.
Right.
So I think that that's something you all need to address at a temporary basis, because summer will be here before we know it. And then when you all see me at final, then we can discuss it even further. But I don't want that to be an issue on final that y'all have not addressed up until that point. I don't think that's fair to your clients. So yes, you all can go again and flush out that. Because I want to make sure that everybody walks out of here today with a complete understanding of what their obligations are. And we're in recess